Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Well, all right. Good morning, everybody, and thank you for coming to the FIA Group Empowering Plans Podcast. I don't know if I'm your host today, but I am one of the presenters. This is Chris Aguiar, one of the attorneys and vice president of Legal Recovery Services here at the FIA Group. And with me is one of my cohorts over in the consulting division. Why don't you introduce yourself, Andrew?
Hi, this is Andrew Silverio. I'm a compliance and oversight counsel at the FIA Group, and it's going to be fun. I'm looking forward to reconnecting with Chris a little bit. He actually was, when I first joined the company, sort of my Subro Sherpa and taught me everything that I knew at the time. But we don't really get much of a chance to touch base anymore, so it'll be good to see what you've been working on.
Yeah, and of course with COVID, and I think, and I don't know if this is public information, I think maybe you don't live on the golden roads of Massachusetts anymore. Is that true?
That's true. I moved out to Cleveland.
Was that in an attempt to ingratiate yourself to Adam more, or was that just because, you have like a undying love for the city of Cleveland?
No, that was literally the only reason, was just to impress Adam.
Got it. Yeah, I mean, it's never a bad strategy to try to impress Adam. Pull Cleveland as more centrally into your life.
Yeah.
That's awesome.
Great.
So how long ago did you move out there?
In November. So it's been the winter and the spring.
All right. How's the weather out there right now?
About the same as Boston. Not great. But, can't really complain.
Well, look, I hate 90-degree weather too, so I agree with you. The weather in Boston has not been great. That's funny. Yeah, but I mean, like Andrew was saying, Andrew and I used to literally sit in the same room, and then he moved on to, I guess I could let him tell you whether the pastures are green or not, but he moved on over to our consulting division. So between that, the fact that I haven't seen anyone at work in a very long time, thanks to COVID, and that he no longer lives with us here in the pearly gates of Massachusetts, we don't get to chat very much. So what have you been working on lately, Andrew? I know that over in consulting, you guys kind of jump around a little bit from topic to topic, but I think you kind of have a little niche specialty. Is that right?
Yeah, so a lot of the stuff that pops up periodically as hot topics, it often kind of centers around specialty drugs, prescription drugs, gene therapy, that sort of thing. And, a repeat offender is drug importation programs. It seems like a decade ago now, it isn't quite that long, that we first saw these programs and then took a look at them in the private sector. Some of the common players there. But they've been, popping up in various forms over the years, and we haven't seen much actual movement from a compliance standpoint. But in the last couple of years, we have at the federal level, as well as some stuff at the state level. But the federal government tends to step in and say, no, that's our area. But yeah, we've seen just in the last few days and weeks some developments there, and we've been looking into that. Specifically, a year and a half ago, actually now, in the summer of 2019, the Trump administration unrolled a plan that had a lot of people very excited to basically allow states to create programs for importing drugs from Canada. And the announcement basically outlined that the HHS and the FDA would review these state programs and approve them. And this would set the stage for the first instance of full federal approval of any sort of drug importation program. I don't know how familiar you great listeners might be with the existing landscape, but really it happens sort of under the radar, and there is just a policy of non-enforcement in a lot of contexts. So it's a very murky area, but this kind of paved the path for the first fully legal, fully legit, federally approved drug importation programs. That said, at the time, there were a lot of question marks still. What types of programs are going to be approved? What's the approval process going to look like? How long is it going to take? And then COVID hit, and everything that isn't related to COVID sort of was put on hold. But we now saw the first time the new Biden administration has chimed in on these plans, and it doesn't look very encouraging. Actually, it wasn't even in any sort of official release directly related to this, but the context was a pharmacy industry advocacy group. They actually sued HHS challenging these rules, saying that they're going to harm the drug industry, the federal government overstepped their authority, and that sort of thing. And it's actually a really interesting situation because in defending against this lawsuit, HHS basically said that your claims aren't mature, the damages that you're alleging are too speculative, because it's still not clear whether or not this program can ever actually get off the ground. So really, in defending the program, they're sort of cutting it off at the knees, saying there's no timeline for the approval of any of these programs. There's still a lot of barriers to the approval of any of these programs. So, it's not a death blow entirely, but it's certainly not encouraging that these programs will get up and running at all, or at least anytime soon. But interesting developments. It was the first time we'd seen any sort of guidance as to what the Biden administration's HHS, what position they would take on these rules.
I mean, I remember that the Trump administration got a lot of positive press, which God knows he didn't get much of that at all, but he got a decent amount of positive press surrounding some of his drug policies, importation policies, his work with the sort of big pharma, some of the pricing things that they saw might be coming. So from your perspective, Andrew, did this kind of move by the Biden administration, did it move the needle, hinder the needle, overturn anything? Because honestly, I haven't been following this at all. So give me like fifth graders' perspective.
Yeah, so if I wanted to kind of boil it down to position statements for the different administrations, it was pretty clear that the Trump administration was trying to push drug importation programs forward. This is a shift from that. I wouldn't go as far as to say that the Biden administration is against it, but it's clear that it's not a priority. I would say that. So, they could just be having it on the back burner and they're going to decide how to proceed later on, or it could just be effectively dead. And there's really no way to know. But it's definitely going to be discouraging for the states that have passed laws to set up these programs. There's 6 of them, I believe, that have passed laws. And there's 2 states that have actually submitted programs for review. And it's pretty clear that those are not going to be reviewed or approved anytime soon. So it will definitely be discouraging for them.
So it sounds like more gridlock from government a little bit.
Yep. Some things never change.
Death, taxes, and gridlock from the U.S. government. There you go, folks.
Yeah. I mean, oddly, it could actually be a good thing for the private sector players who are doing this, because those larger state programs would be really significant competition for them. So, kind of putting a halt on those programs can keep the window open a little longer for the private players to keep doing what they're doing.
That's interesting stuff. I know you just wrote an article about it. I'll definitely have to check it out. I saw the blog post. I didn't get a chance to really dive into the article, though. So I'll definitely check that out and get a bit more of an in-depth Silverio perspective, or whatever we want to call your time in the light.
That'll be our new podcast, the Silverio Perspective.
You're in Cleveland now, so that might get through the suits.
Yeah. So what have you guys been working on over in Subro?
I mean, Andrew, you know enough about Subro certainly to know that it's an old dog. And so not a lot of things move very fast or very much at all. We've been operating with a lot of the same rules for a long time. There has not been anything earth-shattering really since Montanil. Obviously, for anyone listening, subrogation, ERISA subrogation has been in the Supreme Court of the United States 4 times since 2002, the last time being in 2016. The Montanil decision, which basically said that plan participant that gets his hands on a third-party recovery and spends it on non-traceable assets effectively can't be sued for funds that aren't spent on non-traceable assets. And that opens up an interesting quandary, right? Before Montanil, some of us in the industry were kind of blindly hoping that the Supreme Court would draw a line and tell people, look, it's not your money, you're holding it on behalf of the plan, so we're going to put some limitation on this equitable remedy concept that's kind of built in the subrogation recovery concept. But that didn't happen. The courts basically said, look, plan, we acknowledge it's your money, we understand it's your money, but we're not going to let you just sit on your hands and do nothing. We're going to force you to kind of dance for your dinner. And if you don't do that, and a plan participant takes an adversary position or does something inappropriate with that money, we're not going to let you go after them for other money. But that really begs an interesting question, like what disincentivizes someone from getting a settlement and then doubling down on red? And I know that's an extreme example, but Andrew and I could attest that if you gave me $100,000 check right now, I could make it disappear real fast at the federal government, thanks to my expensive law school education. So it can be very easy for a plan participant to make some money disappear if they so chose to do so, and or if a plan isn't really on top of their game. Nothing huge has changed since then, at least not at the federal level. Tennessee did come out with a new law that kind of changes subrogation in Tennessee a little bit. For the most part, it's been pretty quiet. And so I'm kind of been, I don't want to say operating in esoteric land, but every so often we kind of run on theories and hunches to see kind of where this all might go. And when Monsignor came out, we kind of put some language into our template subrogation third-party language to try to establish this concept of trust/fiduciary responsibility over those funds. Now, we all know that, or those of us that understand subro kind of intimately know that plans establish that those funds are to be held in a constructive trust, meaning, for all intents and purposes, even though there is no official trust account set up, that money is being held on behalf of the plan until it's reimbursed to the plan. And so you kind of extending on that concept, we decided to put some language in our plan language that indicated that once a participant takes hold of that money, they're in possession of that money is a plan asset, and they have the ability, you can debate whether they have the authority, but they have the ability to exercise some sort of control over that money, meaning they could reimburse it to the plan or they could double down on black. And that concept, I tried to play with this notion of fiduciary sort of responsibility. And why did I do that? Andrew, you actually probably remember this. I think you did a fair amount of research prior to the inception of our PACE program as to whether a plan can designate a fiduciary. In other words, what makes someone a fiduciary? There are a few things that can happen. A plan can designate a fiduciary. You can kind of be an incidental fiduciary, meaning you purposefully do something that makes you a fiduciary. And the third that I actually just learned about is you can be an accidental fiduciary, meaning you accidentally do something that made you a fiduciary. What I'm trying to do is play with this concept of you're a plan participant, you get this settlement, you get this money, and you do something with it. And that action is the exercise of control. And as we know, Department of Labor defines a fiduciary, among other things, as someone who exercises control over a plan asset. Now, why does all this matter? Because if the courts in Monsignor said to us, you cannot go after someone for their general assets or money that isn't the specific money they received in that settlement, can a plan participant who exercised control over assets, thereby arguably being a fiduciary, can they be assessed penalties under ERISA? Because as we know, ERISA has penalties that it assesses against fiduciaries. And so we tried to play with this concept, this notion of trust penalties, because as you know, a trustee over an asset, if it misappropriates that asset in any way, can be held responsible for that misappropriation. And would you be surprised, Andrew, to learn that there's not a lot of case law on this issue?
I would not one bit.
So here's the funny thing, often in the ERISA context, and you've probably experienced this a decent amount, Andrew, you go do research for health plans, and what you find is there's a ton of case law on issues in the pension world, but it just hasn't made its way over to the health plan context yet. And that's not really the case here either, but there is some stuff in the law. There are instances where courts have sort of set up a possibility that a plan participant could be a fiduciary. And if you can establish them as fiduciary, the next interesting question is, can we get around the sort of ERISA's grant of an exclusive equitable remedy and apply penalties under ERISA? Would the law view penalties differently than sort of just a general lawsuit under Section 502A3 to enforce the terms of the plan? I don't know the answer. I've had people reading our new template language tell me I'm a genius, and others tell me I'm a moron. My response to both of them is the same. I don't want to know which one I am, because if we're finding out, that means we're in front of a judge and something went wrong. If we're litigating this issue, something went wrong. If somebody's going to litigate it, let it be somebody else. But I know you've done some research on the issue, and so I don't know if you have any perspective, but I was interested to find that there is some support for this notion that a plan member can be considered a fiduciary either in that incidental or accidental realm. I'll be fascinated to see one day whether it extends to penalties.
Yeah, that's really interesting. It's sort of like a plan B, right? Stemming out of the challenges that Montanil presented, where The main limitation from that case was based on the plan's right to appropriate equitable relief, right? Saying that you can't impose what would essentially be a personal debt against the participant. Their equitable relief attaches to the actual funds, and if they're gone, they're gone. But if you're framing it as a fiduciary issue, fiduciary liability is personal liability, right? So you just have this alternate avenue to get to the person through this outside of the appropriate equitable relief as a fiduciary claim. And now you have a different route to establish exactly what Montanale said you couldn't establish through that other section of ERISA. That's really interesting. I think the main challenge would be, from my perspective, establishing that those funds that the participant is holding are actually plan assets, right? If you can establish that, then I don't think there's any question that they're exercising control over those assets, especially if they go out and spend them.
See, actually, that's interesting. I've personally not found that to be the concern. In my mind, the concern has always been, remember that 502A3/ERISA grants plans a, quote, exclusive equitable remedy. And so if that is indeed the only remedy available, is the penalty provision of ERISA, which is not under 502A3 technically, does it kind of rest outside of that exclusive remedy? Is it available given that it is not the equitable remedy? And in some ways, you could argue imposing a penalty is tantamount to imposing a personal debt on a plan participant, which, as we know, most of them simply don't have the funds, especially since the whole underlying concept here is they've spent the money. The money that they, in theory, had to pay you is gone, right? Otherwise, we would have been able to get it under the 502A3 action. So to me, it's a really fascinating concept. In my mind, I've never seen the biggest hurdle being a plan asset.
Yeah, so I'm kind of thinking in a context of a different type of plan fiduciary being, the plan administrator, an employee at the plan sponsor or something like that.
Yeah.
If you think of these fiduciary duties being, to prudently manage plan assets, engage in prohibited transactions, that sort of thing, with these duties being in place to protect the plan against someone misappropriating plan assets, right? You kind of need to be able to draw a direct liability to that fiduciary, because otherwise, someone in control of plan assets, what's to stop them from just, pulling funds out of the claims account, buying a Ferrari and riding off into the sunset once that money's gone, right? If you can't hold them responsible, what's the point of the fiduciary duties at all?
Yeah, I totally agree with it. And it's just, you'd think all these years of ERISA jurisprudence that this issue would have come up by now, right? And have been litigated. But so far, there's a little bit of it in the case. Real quick, let me grab it. I don't want to misquote it. There was a case that came out of, again, pension plans that do indicate that a plan trustee can also be a plan beneficiary. And basically, in the case, the defendant, he was a trustee of the pension plan, but he also drew pension payments from it. So he was both a trustee and a beneficiary of that plan. And the plan tried to bring a breach of fiduciary duty against him by offsetting his pension benefits. And the court said there must be intent to create a trust relationship rather than a contractual relationship. And so the court was able to sort of, in that case, determine that there was no intent to create a trust relationship. Accordingly, there was no fiduciary relationship. And so maybe it comes down to the fact that, what do the plan members understand they are doing when they are accepting that settlement fund? So it's interesting. Like I said, I found it, to me, the concept of plan asset, first blush to me, was an easier hurdle. And so it's just interesting to hear that you think that's perhaps a more prominent hurdle. Like I said, I don't know that you're wrong per se. I could be wrong. I have no idea. The fact of the matter is, the funds are not being held by the plan. They're being held by, either some external trust account, a special needs trust. All really going on is the courts have long held that it's being held in trust for the plan. If it is, then in my head, it's easily identifiable as a plan asset. But nothing is easy. Otherwise, we wouldn't be employed, right, Andrew?
Yeah, for sure.
Amen to that.
Yeah, so hopefully some of you are still awake. This is what happens when you get two lawyers talking to each other. But thank you so much for tuning in. If you have any questions about anything we've talked about or anything at all, please reach out. We're here to help. We're here to answer your questions. On behalf of myself, Chris, and the FIA Group team, thanks for tuning in, and we will see you next time.
Thank you so much, everybody.